everyone. Today, our topic is Social Science Class Ninth Democratic Rights. Before starting, I would like to request you all to please subscribe my channel and watch my previous videos that are on my channel. So, let's start with our today's topic, democratic rights. Now, whenever we are going to discuss about democratic rights, the first question is what is democratic, what is right. Now when I talk about democratic, or when we talk about democratic, it means that whatsoever that is democratically created, that is democratically there, that means where the people are electing their government, people they are creating their laws, that is a democratic procedure. The second part is rights. Now, there, what is right? Because today's topic is basically about rights of citizen of the country. Now, the question arises, what is rights? Now, rights are an entitlement to something, whether to concepts like justice and due process, or to ownership of property, or some interest in property, real or personal, whatsoever it may be. These rights include various freedoms, protection against interference with enjoyment of life and property, civil rights enjoyed by citizens such as voting and access to the courts, natural rights accepted by civilized societies, human rights to protect people throughout the world from terror, torture, barbaric practices, and deprivation of civil rights and profit from their labor, and such like American constitutional guarantees, or Indian constitutional guarantees, or Australian constitutional guarantees. You may have the numerous constitutions are there. I'm just having one example of American constitutional guarantees where right to freedom of speech, press, religion, assembly, and petitions are there, because that was the oldest one written constitution of the world. And because of that, I just have taken the example of one. There are numerous. That means the right is basically an entitlement that is given by the constitution. Either it may be the case of justice, or the process of justice, or it may be the ownership of property, or it may be the interest on property, or it may be the various types of freedom that we are having as per our constitution. That means Indian constitution, or protection against interference or enjoyment of life and property, civil rights, anything that can be possible. That's what I'm talking about, that these are known as rights. That means whatever the things that are provided to us by the nature, being human, certain amount of rights are given to us because we are living in civilized society. These all things are known as rights to us. Case study like here in this NCRT book, one case study of Guantanamo Bay is there, where about these are the past things. Later on, the people of Guantanamo Bay, they were released because of Amnesty International and many people, those who were just against this type of taken out the rights of it, because that particular prison, Guantanamo Bay prison, was not on the American soil, but that was controlled by the US forces. About 600 people were secretly picked up by the US forces from all over the world. They were put in prison in Guantanamo Bay, an area very near to Cuba, controlled by American Navy. They were linked to the attack on New York on 11 September 2001. The US Army arrested them, interrogated them, and decided whether to keep them there or not. There was no trial before any magistrate in the US. Amnesty International reported that the prisoners were being tortured in ways that violate the US law. The United Nations Security General said the prison in Guantanamo Bay should be closed down, but the US government refused to accept these pleas, and case goes on, goes on, goes on. Many of the people, they were released, but even today, it's nearly nowhere that the prison is closed or not. Nobody knows about in reality, because that is a very secured area and nobody is allowed, the press and others are not allowed to move in that particular direction or at the Guantanamo Bay. Why do we need rights in a democracy? The basic question is, why do we need rights? And that also in democracy, because for democratic election to take place, it is necessary that citizens must have the right to express their opinion from political parties and take part in political activities. If I don't have the right, I will never be able to express what I want to, because my opinion is never going to be accepted by anybody. The person who is in power, he will continuously hold the power. Because of that, I needed my democratic right. Rights are guarantees which can be used when things go wrong. Anything, if it goes wrong, these rights are my guarantee that I can use them, and then I can be properly, being in this civilized society, I can utilize them, so that whatsoever the wrong thing is done by somebody else must be, as per law, it must be corrected. The government should protect the citizens' right. That is again a democratic right, because if my government, the government of India, if they are not ready to help me to protect my rights, then the democracy cannot exist in that particular fashion. In most democracies, the basic rights of the citizens are written down in constitution, except British, but that also for many years, the rules and regulations, they don't have the written constitution. But rest of the world, they are having written constitution, and the most modern in 1991, 92, and 93, by that particular time period, a constitution was created, written. The most newly born constitution of the world is South African constitution, and that is also written particularly because that was not free. That country was not colonized country, but there the rulers were the same people, those who are even in that particular country, the whites. They were controlling the power till 1991. After that, Nelson Mandela was freed, and then the constitution was again rewritten. There the rights are more clearly defined. But then also in democracy, that constitution where everything is written, and that is known as whatsoever that rights are given, those rights are known to be the written rights to each and every individual. Rights that are written in the Indian Constitution. Indian Constitution provides for six fundamental rights, and they are right to equality, that is from Article 14 till Article 18. These are known as right to equality. Then the right to freedom, Article 19 to Article 22. That means 19, 20, 21, and 22. Collectively, they are known to be as a right to freedom. Then right against exploitation is Article 23, 24. Then right to freedom of religion is known as Article 25 till 28. Then cultural and educational rights are Article 29 and 30. Right to property, it means the right to property, which was later on in 1977, was diluted by constitutional amendment and secured to some extent by articles like Article 30A, 31A, 31B, 31C, and finally the right to constitutional remedies, Article 32 to 35. Now, why there it is written 6, whereas you will find it out that I'm having 7 points. Only one reason, because right to property, it is diluted, and we don't find this particular article anywhere. 31A, 31B, 31C, these are some of the basic rights. And because of that, in general, at class 9th level, you must know about that these are the 6 fundamental rights that are even till date we are having. Now, the government cannot dilute other rights because they are the fundamental to our constitution, except some cases are there, like as per the directive principles of the state policy, you can question, but that these questions are going to be in your graduation and post graduation, or if you are going to be in future law student, then at that particular time period, these right to equality, right to freedom, all these are going to be clarified. At this particular level, we are only going to be a basic knowledge about all these different rights that are in the Indian Constitution. General characteristic of fundamental right. The fundamental rights are guaranteed by the Constitution of India. They are judiciable and enforceable by the law. They are not absolute because there are certain restrictions from the Constitution also, and the government can also restrict some of the rights. They are enforceable even against the government, even against the state. Now, when we talk about in political science or in civics that you normally call, if you are calling state, it doesn't mean Madhya Pradesh state or Gujarat state or Uttar Pradesh or Karnataka or Tamil Nadu or Assam or Jammu and Kashmir or Punjab or Rajasthan. We are not talking about that state. Here, state means government. It may be provincial government, it may be central government, or it may be a local government, but then also the state means the government. They may be suspended, not all, like right to life can never be suspended, except if somebody is hanged till death by judges. That means the justice is delivered there. They may be restricted or abridged with regard to armed forces. Now, these fundamental rights, many of it or 100% of it, can be restricted in armed forces, and they are restricted. They can be amended as per Article 368, and because of that article, Article 31, right to property, was totally abridged by Indian Parliament in year 1977. Then let's start with the different rights of our constitution, that means the fundamental rights. Article 14 to 18. The first article is Article 14. As per Article 14 of our constitution, the laws apply in the same manner to all, regardless of person's status. This is called the rule of law. This applies to citizen and non-citizen and natural and legal person, all of them. It means if the person is within the country of India, that means in the person is in the boundary wall, or that means the geographical border of India. I'm talking about geographical control of India. The person is Indian citizen or not, that doesn't matter. The person is by birth a citizen of the country, or by legality he adopted the citizenship of India. This article, Article 14 of our constitution, applies to each and everyone. According to Article 15 of the Constitution, the government shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. As per Article 16, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 17 of the Indian Constitution mainly deals with the account of untouchability. This article puts restriction and prohibits the practice of untouchability. It ensures that untouchability is eradicated in all forms. Any kind of disability that is arising out of untouchability is considered as an offense. Article 18 states that no title, not being a military or an academic distinction, will be conferred by the state. Right to freedom. Article 19 to 22. As per Article 19 of the Constitution, all citizens have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of territory of India, to practice any profession, or to carry on any occupation, trade, or business. But with a restriction, that doesn't mean you can do any type of occupation. That means smuggling or theft or dacoity or kidnapping is allowed, because these are legally not accepted. Similarly, you can reside and settle in any part of the territory of India, but with certain restrictions, like in Arunachal, Nagaland. You cannot. In Jammu and Kashmir till 2019, this restriction was there. Now that had been taken away. Is totally a different thing. To form association or union, but that should not be against the Union of India. These are certain amount of restrictions as per Article 19 also. But this is known as right to freedom, because you can speak, you can have your expressions, you can peaceably and without arms, you can assemble at any place, you can form any association or union, and so on. That's why Article 19 to 22 is collectively known as a right to freedom. Article 20. According to Article 20 of the Constitution, no person shall be convinced of any offense except for violation of law in force at the time of the commission of the act charged as an offense, nor be subjugated to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. No person shall be prosecuted and punished for the same offense more than once, and no person accused of any offense shall be compelled to be witness against himself. Now, these three are one of the most important things. You see, no person shall be convicted of any offense except for violation of the law in force at the time of the commission of the act charged as an offense. Now think about today, if a particular thing is not crime, suppose that killing of a person is not crime in our country. Earlier this was there that if a baby is killed within the womb of her mother, then that was not taken as a crime. Later on, the law was made, and after that, female foeticide was treated as a criminal activity. Now, these type of criminal activities are not allowed now. But if the person had done something like that before the law is commissioned, then that person cannot be charged for it. You cannot be charged for that particular crime. You must understand this. The second point explains that person shall not be prosecuted and punished for the same offense more than once. Suppose that Mr. A is penalized for killing Mr. B and he was given 15 years of jail or life imprisonment or anything. If he is not hanged till death, then the person is living. Suppose that for 10 years he was given this particular judgment that he's going to be for 10 years, he is in jail. Why? Because he killed Mr. A. Later on, when Mr. B was out of jail, he just went there and killed Mr. A, who was till now living. Now, the person cannot be prosecuted because as per the law, Mr. A was already killed 10 years earlier. Then it means even after 10 years, the person is killed and he cannot be prosecuted for that. No person accused of any offense shall be compelled to be witness against himself. You can watch in movies and serials that the person, police is beating the person. Say, you have committed the crime. Yes, you must accept this. The person may accept. Yes, anybody can accept. Yes, sir, I've done this one. But when you are presented, when the person is presented before the first class magistrate, he can deny. No, sir, I hadn't done anything. And whatsoever the thing that is accepted in front of police is just gone away. You can remember in many of the serials and movies, this thing had also happened. This is what right to freedom under Article 20 explains to us. Then comes Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. A person cannot be deprived of his life or personal liberty, whatsoever the liberty is given by the law. You cannot take away, the government cannot take away, except one way, and that is the procedure that is established by law. Then comes Article 22 of the Constitution. Article 22, 22.1 and 22.2 has the below provisions in Article 22. Well, a person cannot be arrested and also detained without being informed why he is being arrested. However, a person who is arrested cannot be denied to be defended by the legal practitioner of his choice. In fact, this means that the arrested person has the right to hire a legal practitioner to defend himself or herself. Well, every person who has been arrested will be produced before the nearest magistrate within the 24 hours. For this, the police department had taken a new turn, or many times we have seen in movies that they arrest the person on Saturday so that they can have excuse, sir, because on Sunday courts are closed. We are unable to present the person within 24 hours, and because of that, they present the person on Monday, and by that hour, the person is arrested for 48 hours, and the police is having time to force the person to accept his crime. The custody of the detained person cannot be beyond the set period except by the authority of the magistrate. If the magistrate permit, then only the person can be arrested for more than 24 hours, because the authority of magistrate had given that, okay, you can arrest this person and then present in my court, which will take 72 hours or 48 hours or whatsoever the time may be. On the basis of that, that authority must be given by the magistrate. However, the Article 22.3 says that the above safeguards are not available to the following. First, if the person is at the time being an enemy alien. If the person, while he was arrested, is an enemy to the nation, to the country, then he must not be taken, he must not be presented before the magistrate within the next 24 hours. Second, if the person is arrested under the certain law which is made for the purpose of preventive detention. Two parts of Article 22. First part deals with the case of ordinary law, that is when a person is alleged to have committed an offense, and the second part deals with the cases of preventive detention, that is when police authorities are suspicious of the person, that this person had done some crime which is not acceptable by the people, by the country, and he may do some heinous things, or maybe criminal, maybe a terrorist, then in that particular case, this Article 22 is withheld. That means preventive detention of law, if that had taken place, then this law, this article can be abridged for that particular individual. But for the common people, this article hold its position. Then comes the article right against exploitation. That means Article 23 and 24. As per Article 23 of the Constitution, traffic in human being and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination on ground only of religion, race, caste, or class, or any of them. That means there cannot be any traffic of human being or begar or something like that. This was what Mahatma Gandhi, Dr. Bhimrao Ambedkar, and others felt what's going on in Hindu society or in our society. Then comes Article 24. As per Article 24 of the Constitution, no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. No child below the age of 14 can be employed by any person in any factory or mine or any hazardous type of employment. Then comes right to freedom of religion according to Article 25 of the Constitution, subject to public order, morality and health, and to the other provisions of this part. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate their religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. That means even under this law, to maintain public order, to maintain morality, to maintain health and other provisions, all persons are equally entitled to freedom of conscience and right freely to profess, practice, and propagate their religion. The government of India doesn't have any religion as the state religion, and because of that, every individual is free to propagate their own religion. Nothing in this article shall affect the operation of any existing law or prevent a state from making any law. Number one, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. And second, providing for social welfare and reform or throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. This means basically this law is for social reform, that whatsoever the on the basis of caste and creed and religion, or the male or female on the basis of that, if the person is restricted from entering any temple or any pond or any other places of public, then the person who is just restricting is committing a crime, and the person can be withheld by the police for allegedly taking out the right of freedom of religion from somebody else. Then comes Article 26 of our Constitution. Subject to public order, morality, and health, every religious denomination or any section thereof shall have the right to establish and maintain institution for religious and charitable purpose, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with the law. Everything must be in accordance with the law. But then also the person is having a right to maintain its institution, can propagate its religion, can make a charitable trust, can do many other things, so that he or his religion can also spread. and anybody can accept that religion for his own betterment, morally or economical or whatsoever may be the reason. Then again, right to freedom of religion in that Article 27, no shall, as per Article 27 of the Constitution, no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. That means, as per this, as per Article 27, no individual can be compelled to pay any tax whatsoever. The tax that is paid can be distributed equally to any religion, or without having any type of religious affinity, that money can be spent. But if the tax that is collected by the government and we find it out that this particular tax that is collected is only directed towards this particular religion, then again Article 27, the government is trying to restrict. Because of that, this must not be, and right to freedom of religion is given in our Constitution. Then comes Article 28 of the Constitution. No religious instruction shall be provided in any educational institution wholly maintained out of state fund. If the government is maintaining, either it may be certain amount or wholly, then that institution cannot propagate one religion. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. No person attending any educational institution recognized by the state or receiving aid out of state fund shall be required to take part in any religious instructions that may be imparted in such institution, or to attend any religious worship that may be conducted in such institutions or in any premises attached thereto, unless such person, or if such person is a minor, his guardian has given his consent thereto. That means if any institution is established by the government, there one religion cannot be propagated, or if it is, then the parents' consent must have been taken by that institution, then only they can propagate their religion. Then comes cultural and educational rights as per Article 29 of the Constitution. Any section of the citizen residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. No citizen shall be denied admission by any educational institution if that educational institution is maintained by government or receiving even 1% of state fund, then that religion cannot deny any admission on the grounds only of religion, race, caste, language, or any other thing, any other case. That institution cannot deny admission of any individual. Then comes Article 30 of Constitution. This right is given to minorities to form and govern their own educational institution. Article 30 is also called the Charter of Educational Rights. Article 31, all religious and linguistic minorities have the right to establish and administer educational institutions of their choice. And Article 32, the state should not, when granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of minority, whether based on religion or on language. Now, this particular charter, Article 30, is known to be as Charter of Educational Right, because as per this right, any individual can establish, it may be the linguistic minority, it may be the religious minority, everybody can establish their own educational institution of their own choice. And the state cannot, if they are granting aid to any educational institution, can discriminate against any educational institution only because of that the minority is managing this school or college or any educational institution. Then comes Article 31, right to property. Article 31 of the Constitution not only guarantees the right of private ownership, but also the right to enjoy and dispose of property free from restrictions other than reasonable restriction. The article states that no person shall be deprived of his or her property except by authority of law. It is also mentioned that compensation would be paid to a person whose property has been taken for public purpose. But the Constitution's 44th Amendment Act 1978 signifies the demise of fundamental right to property. Before 1978, there were mainly two articles to protect private property acts, 19(1)(f) and 31, but they were repealed by constitutional amendments, and thus private property was left defenseless. Now, remedies for enforcement of rights. Article 32. Article 32 of Constitution give the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. The Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Without prejudice to the powers conferred on the Supreme Court by Clause 1 and 2, Parliament may by law empower any other court to exercise within the social limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. The right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. Now, it means that only because of certain amount of constitutional provision, this article can be taken out. But later on, by the judgment of Supreme Court, that they decided and they said that this article cannot be taken by any parliamentary act. Not only that, this act give Supreme Court certain amount of power, which we will talk later on. That is, as with the help of writ or direction or order, that Supreme Court direct any police authority or any individual to act over it. Now, remedies for enforcement of right, Article 32, we have gone through. The word was writ. Now, the question is, what is writ? Writs are written order issued by the Supreme Court of India to provide constitutional remedies to protect the fundamental rights of citizens from a violation. Now, some of the facts about writs in India. Article 32 also empowers Parliament to authorize any other court to issue these writs. Before 1950, only the High Courts of Calcutta, Bombay, and Madras had the power to issue writs. Now, you know already what the writ is. Article 226 empowers all the High Courts of India to issue the writs. Writs of India are borrowed from English law, where they are known as prerogative writs. A writ petition is essentially a court petition of extraordinary review asking a court to intervene in a lower court's decision. Under the Indian legal system, jurisdiction to issue prerogative writs is given to Supreme Court and High Courts of Judiciary or Judicature of all Indian states. Part of the law relating to writs are outlined in the Constitution of India. Now, basically, writ is a written order by the Supreme Court of India. Before 1950, only three places were there: Calcutta, Bombay, and Madras High Courts, those who were having the power to issue these writs. But after with the help of Article 226, all the high courts of different states, they were given this power that they can issue writ to the people or to the police authority for certain things. Now, these writs can be issued in different form. They are, first one is habeas corpus. Habeas corpus is a writ that is enforced to protect the fundamental right to liberty of an individual against unlawful detention. This writ commands a public official to deliver a detained person in front of the court and provide valid reason for the detention. However, this writ cannot be issued in case the proceeding is for contempt of legislature or a court. Now here, the person is taken by the police and without explaining any reason, then this habeas corpus can be issued to the police officials. Then comes ceritorio or certiorari. The writ of certiorari is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. The Supreme Court issues the writ of certiorio in case the decision passed by the lower court is challenged by the party. It is issued in case the lower court finds it a matter of over jurisdiction or lack of jurisdiction. It is one of the mechanisms by which the fundamental rights of citizens are upheld. The next is prohibition. It is a writ issued by a higher court to a lower court to enforce inactivity in the jurisdiction. It happens only in case the higher court is of the discretion that the case falls outside the discretion of the lower court. Writ of prohibition can only be issued against judicial and quasi-judicial authorities. That means with the help of this, the higher court, that means High Court of the state or the Supreme Court, can direct to the lower court that you cannot have any jurisdiction over this particular case. Submit it to us. Mandamus, the writ of mandamus is issued to a subordinate court, an officer of the government or a corporation or other institution commanding the performance of certain acts or duties. Unlike habeas corpus, mandamus cannot be issued against a private individual. Try to understand. It cannot be, a mandamus cannot be issued against any private individual. The writ of mandamus can be used to order the completion of a task, or in other case it may require an activity to be ceased. Quo warranto is issued against a person who claims or serves a public office. Through this writ, the court inquires by what authority the person support his or her claim. This is against also a person who is holding public office. Through this writ, the court inquires into the legality of a claim of a person to a public office. This writ prevents the illegal assumption of a public office by an individual. Suppose that a person is controlling a particular official, or he is just not leaving a place. The issue of quo warranto can be done by High Court or Supreme Court of India, that in what capacity you are holding this particular position. Now, there are certain amount of expansion of rights. That means I'm talking about fundamental rights. Now, these fundamental rights are source of all rights. Our constitution and law offers a wider range of rights. Over the years, the scope of rights had expanded. Various new rights are now: right to freedom of press, which is not a fundamental right, but then also because of these fundamental rights, the right to freedom of press is there. Right to information, right to education, right to be informed, right to life, that is again written there, and right to life. Then constitution provides many more rights which may not be fundamental right, but then also they are fundamental to us, like right to property, right to vote in election are also some important constitutional rights. This is all about this particular chapter. This particular democratic right is only a small portion of the whole constitutional fundamental rights. When you will grow up, when you will take political science in class 11th or 12th or even beyond, then you will definitely know about more of these rights. I'm just having a gist of this. I tried my best to explain only some basics of fundamental rights. Goodbye, everyone. Thank you for watching.